Hey Outdoor Legal Warriors, in this video I'm going to cover 3 myths about theft cases in Washington State. Lots of times people think, hey, I have a defense to this theft charge because of X, Y, or Z, and you'll be interested to find out that a lot of these thoughts aren't actually true. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. Now I'm just going to jump right into it. What is theft defined as in Washington State? We have to start there so we can talk about what the myths are that we need to know about. And, theft sort of means, stealing something that doesn't belong to you. But when we talk about these myths, knowing what the law is can explain why these myths that people believe aren't actually so. So in general, theft is defined in Washington State under a definition law, RCW 9A.56.020. Now that just defines what theft is, and then there's different levels of theft someone could be charged with. Theft third degree, which is a non-felony, less than $750 total value. Theft second degree, which is more money, which is a felony, than theft first degree, which is even more money. But here, what I'm going to talk about as far as defenses that maybe aren't actually so, that applies to all of those type of thefts. So moving back to the definition, theft means to wrongfully obtain or exert unauthorized control over the property or services of another or their value with the intent to deprive them of such property or services. So it just means, hey, you intended to take the property. You intended to take the services, right? Like if you use someone else's dumpster, that's actually theft of services because you're not paying for that dumpster, right? If a police officer prosecuted, I've seen that case, believe it or not. Another definition of theft is by color or aid of deception to obtain control over the property or services of another with the intent to deprive them of the services or the property. Now, in that situation, you have to just take control over the property with the intent to steal it. You don't actually have to steal it. So knowing that those are the definitions, let's talk about the myths. Myth number 1 is that, hey, if I put the property back, or if I return the property that got taken out of the store without paying for it, that somehow undoes the original criminality of taking the property to begin with. Can't I just bring it back and then let's just forget about it? We're all good. No, that is not a defense. That's a myth, and we don't want you to fall for that out there because you might get a call. Right? You might get a call from the store, an officer, hey, just return the property and we will forget all about it. And while the officer has the power, or the store has the power to not report it, that would not be a defense to a charge if we return the property after we already had the intent to wrongfully take the property from the store. And I've seen that happen. I can think of a couple cases here locally. I have an office in Linwood. Linwood is a big retail city that's got all types of stores. And I can think of at least one time, if not more than one time, where the store says, just bring it back and we'll forget about it. They bring it back and trust me, they didn't forget about it. So we could still try to use that type of thing to tell the prosecutor, hey, at least they brought it back. It still might help your case. But don't think because you return property after you've taken it that it no longer counts as a theft, and it somehow makes it now legal when it wasn't legal to begin with. Myth number 2 is probably one of the most common ones. It's like if we say, I meant to pay for it, that somehow is going to get us out of trouble. And the corollary to that is, I'll go ahead and pay for it now. Right? I meant to pay for it, or can't I just pay for it now? And somehow that's going to fix the problem. And that is also a myth. That's just simply not how it works. If you think about it from the store's perspective, anybody who gets caught, at least a lot of people are going to say, oops, I meant to pay for it, or I meant to scan it, right? We see the self-scanners all the time now. I meant to scan it, right? And it doesn't get scanned. And the stores and whatnot, they're going to say, we don't care, right? You already passed the last point of sale. You're outside in the parking lot. Or you've got, your 3 steaks and you only scanned one of them. And, you're going to say, look, I meant to. But the store's not going to care. They're going to say, you took some action that was inconsistent with their ownership rights, you took it outside the store, you didn't pay for it, we're going to prosecute you to the fullest extent of the law. And a defense in those situations, which is hard to prove, is, hey, they still have to show intent. Remember we talked about the statute, we have to intend to deprive them of their property. And while we can argue we didn't intend it, prosecutors, courts, stores, they're so tired of people claiming that, it sort of falls on deaf ears. So we do want to try to use that if we're defending the case, but it's not going to, magically make a case go away because we either said we intended to pay for it or, hey, we're going to pay for it now. So that is probably the second myth that we want to disabuse someone of if they're in this unfortunate situation where they did just get distracted and leave the store. We can't take a holier than thou approach because it's not going to be listened to. The louder we yell about that, the more the government will push back. The third myth is one that we see also a fair amount is, hey, I never left the store with the property. How can I be guilty of theft? And what type of situation can that happen in? Well, that can happen in a couple different ways. One could be price tag switching, right? Price tag switching, imagine Goodwill. Now, don't go out there and do this, but it's a rampant problem that we see at Goodwill stores. Goodwill stores, at least in our local area, they have different tags, right? It might be easy to take off, a $5 price and put on a $2 price. And let's say somebody sees that sweater that's listed for $5 and they'd rather get it for $2. So they find a $2 item, take that tag off, stick it on the sweater, you're walking around with it. Well, they can get you for theft right there because you took an act inconsistent with their ownership rights. You're trying to make it look like you can buy it for $2 instead of $5. And most of the time they're going to wait until you make the purchase to try to stop you, but they don't have to. You don't have to leave the store because remember, if by color or aid of deception we attempt to obtain control over property or services of another with the intent to deprive them of the value, that extra $3, that's defined as theft under the local RCW. A second example would be the people that go into a changing room, right? They go into a changing room and they put on, they put on an extra pair of pants, right? And now they're walking around with 2 pairs of pants and they don't have to wait for you to leave the store to stop you. Another example would be that we see is you stuff 3 things in your bag, you're walking the store and all of a sudden you notice you're getting watched. You're getting watched. Uh-oh, I think security's on you. Well, I'm going to walk over here, I'm going to dump this over here. I'm going to dump it. Well, if you already stuffed stuff in your bag and let's say you also cut off sensors or something, it's pretty clear those were acts that were inconsistent with their ownership. They don't have to wait for you to complete the theft and get outside the store because by definition that theft is completed already once they can show you took those acts inconsistent with their ownership with the intent to deprive them. And so it's sort of a rule of common sense, but I'm only making this video so if you're in this situation, and I hope you're not, you can realize what might work and what is a myth and won't work, especially if for some reason you're representing yourself or you have a public defender, something like that. You need to tell your attorney actually what happened, but don't, just yell to the world and it's so unfair because I didn't get out the door. They didn't really catch me. That really doesn't help you emotionally. We need to focus on trying to get to the bottom of why something happened and what's going on with our lives. There's usually depression or anxiety or just a strange feeling we have when we take something. Most of the time the people we deal with, they don't even sure why they're doing it. And I want to make sure that we avoid using these myths to sort of get in our way of accomplishing what we need to about, not only getting a good result in the case, but trying to feel better. Because when we have these things happen, it's a sign of something else that's going on. Something else is going on in the person that's involved in the situation. So those are the 3 myths I wanted to cover. I hope you found it helpful. If so, you can always use a like, you can always use a subscribe just so more people can see it and more people can get the help they need. More importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this for more than 20 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.